Okay, there, we are all set. This is Great Lakes Home Health Services versus Van Duzen et al., docket number 20-154CB. This is the time set for the hearing on the plaintiff's motion to enforce court order and for sanctions. I'll take your appearances first, please, starting with the plaintiff.
This is Ryan Bohannon, Your Honor, representing the plaintiffs.
Good afternoon, Your Honor. Brendan Beer, representing the defendants.
Okay, thank you. Mr. Bohannon, you want to go ahead?
Yes, Your Honor. This relates back to discovery requests that were served, I believe, in June. And the defendants basically objected to the responses on the grounds that they were overbroad because the case lacked merit. We then filed a motion to compel in September. Through discussion of this case, there's also related cases pending around the state, other non-compete, non-solicit violations. Through discussing, we agreed on a narrowed category of documents, put that in form of a stipulated order, and then the court entered that order in October. We were supposed to receive documents in November. We did not receive them until December. In January, we started having calls with the other side about the deficiencies. We also were engaged in what seemed to be cooperative efforts in their own discovery request to us, where we were narrowing them. And ultimately, we agreed on April 2nd as a day that they would produce full responses to that court order, and we would produce our discovery responses. April 2nd came and went, and we didn't get anything in return. And there's really 8 categories of documents that we need, 2 of which go right to the heart of the case, and we're still waiting on. And they're now, according to the response brief that was filed, they're back to defending that they don't think they should have to comply with the court order because our case lacks merit. I can go through each of the 8 categories if Your Honor would like. I know that can be a little tedious, or I can maybe just highlight the most important items.
Why don't you just highlight the most important items? Because I did study very carefully as far as what was ordered, what the problem described in the letter was, and then what relief you're seeking. Okay,
so it's our theory in this case, and it's been brought that that our former employee, Brandy Van Dusen, that she is soliciting and competing in violation of her agreement. And the defendant enterprise, the Caroline Health Group enterprise, is composed of 2 sections, one palliative care or physician services, the other hospice. Our client will present affidavits that says that the way that this competition is happening is that Miss Van Dusen is going into her old referral sources and referral sources that she knows are other, our Alara Caring's referral sources, and she's introducing them to palliative services and to hospice services. There's over 20 documents they did produce in discovery that backs this theory up, that shows she is indeed talking to them about hospice services. And then a patient who's on palliative care is close to end of life, and that person's going to get switched over quickly to hospice. So she's getting the foot in the door, and then the competition is happening when she's taking over that referral source, and then that referral stays with Caroline, and it takes it away from Alara Caring, or she's competing at least. So the biggest thing we need in order to show damages is we need 2 things. We need Caroline's hospice admissions, palliative admissions, and the revenues for those referral sources. And then we need to compare that to Alara's data from the same referral sources in order to show damages. We can't possibly produce the second part of that equation, our part of it, until we get it from Caroline. They were ordered to produce any hospice data and revenue admissions from any source that Van Dusen contacted. Their response to that was that in the order, their response was, well, she isn't, let me grab it here. It says specifically, there's no admissions attributable to her. I mean, that's not responsive to what the order said for Caroline to produce. And then in the other response on the palliative side, they said they did produce some documents, but she's worked at Caroline since July of 2019 to the present. They only produced data from January 2020 to October 2020, and it's unreasonable. Or not, I apologize, not unreasonable, it's illegible. We can't read it. And we've made that known, and we still don't have it. We're getting close to the end of discovery, and we need to turn this data over to our experts. And defendants have now filed a motion to compel our data that we can't possibly give to them until we see what theirs is.
All right. Thank you, Mr. Beer.
I apologize, Your Honor. Did I what?
Pardon me?
I what? Is it my turn to respond?
Yes, I think he's done, so it's
right,
your turn.
so
I asked him to just highlight the important ones, so.
Yeah, I mean, here is my client's position on this, okay? Despite Mr. Bohan, I'm not even gonna get into the history of it because he and I just don't see eye to eye on how we ended up here today. But there was a stipulated order entered in this case where we very carefully negotiated as a part of another case where we were sent to see a discovery facilitator out of Oakland, and we went through a long process to work towards a similar list in another case, okay? And so we incorporated a large part of that type of list here to try to solve the problems we were having here, which in our position was your discovery requests are way overbroad, seek information that's not at all relevant to the case. And so we look to narrow the scope of those to these requests. And part of what's critical in this case is they talk about this Caroline Enterprise. These are two separate companies, Caroline Palliative Care, PLLC, which is a physician services company owned by a Dr. Keelhorn, okay? That's on one side of the case. And then Caroline Health Group Michigan, okay, which is a completely separate company owned by Joseph Mead, who's here today. They do not have common ownership. They do not do the same things. One is frankly a doctor's office that sees patients in an assisted living center, for instance. The other is a hospice provider. They hold different licenses. They're owned by different people. They have some loose business affiliations where they work together on occasion, but they are not the same entity and they do not do the same things. Okay, and that's why I attached those in my response brief, because what you have here is a situation where they're suing Miss Van Duzen, a former employee, for violating a covenant, and they're seeking hospice revenue. And what our responses said, and the reason G and H, which is what's in the order, it's actually bullet points, but in the exhibit, it's listed as G and H. The reason there are two separate ones is our position is one says, subject to a protective order from June 1 of 2019 to the present, Caroline Health Group Michigan, LLC's palliative or hospice admission and revenue data from each source that Van Duzen contacted or solicited. And then there's a mirror of that addresses the same question for Caroline Palliative Care, PLLC. So our position from the beginning of this is we will give you all admission and revenue data, whether it's related to physician services or what they call palliative care, or whether it's related to hospice. If it's solicited by Van Duzen, if it's anything that stemmed from her efforts, we'll provide it. And we did that. We gave them thousands of pages, calendars of every activity she's had since she's left, and reported to them every dollar that Caroline Palliative Care, PLLC, has reaped as a result of her efforts. What we said to them is, we can't give you hospice data because of what we said since the first day this case was filed. She does not work for Caroline Health Group Michigan. She's not employed there. They do not pay her a dime. She works for the other entity. She has not been trained to provide hospice, and her employer is not licensed to provide hospice. And therefore, any revenue that this entity she doesn't even work for is deriving from providing hospice care is not relevant. I mean, imagine that scenario if you have an employee leave and you just sue two different companies like they're the same thing, even though they're not. They don't even share common ownership. and you say, hey, we want your revenue data for any business you reap at these same locations, even though this woman doesn't work for you and does nothing to solicit business on your behalf. And what's funny about this is my motion to compel that's coming up in this court down the road, all I ask from Alera that they won't provide us is, hey, who did she call on for you when she worked for you? Who were her referrals, whatever that is, when she worked for you? And talk to me about who they were, what your revenue was with them while she was employed there, and what it is today, so that I can see, has it gone up? Has it gone down? Have you gotten business, lost business? Her referral sources at Alera are what is relevant, not what they are now. If she called on referral source A, B, and C at Alera, those are, to the extent they're even arguably protectable, those are the referral sources we should be talking about, not the new ones she has at our company. It's what she had for them, their business interest. It's important, not ours. And they won't give me that. I mean, I could find out who they are just by asking her, and they still won't give it to us. But they act like they're entitled to this when she doesn't even work for this entity. And so our position is we provided them with, seriously, thousands of pages of documents in response to this order. I have nothing left to give, honestly. And the hospice the revenue data we've given them that they say they can't read, that's the manner in which we keep it, which is what we're required to give it to them. The order doesn't compel us to produce it in any particular way. This is something that came up months after the order was entered and after our production was made last year. And that's not a new issue, because we just had this same issue come up in another motion, and another judge told them today, yeah, you didn't specify that it come in any particular form. So they gave it to you in the manner that you provided it. That's fine. We just got that order at 9:30 this morning from a different judge. So these issues are coming up late in the game. They've had these responses for months. And all these talks they have that they say they had about our deficiencies, they were not about our deficiencies. They were about their own deficiencies. This came up, you can see it in the communications. This kind of came up as a side piece. It was all about all the trouble they were going through to try to respond to our responses. This came up, this issue of hospice revenue has come up in these cases because they are, well, the other case is what it is. In this case, it's a problem for us because what revenue is generated by either one of these companies has nothing to do with defendant Van Dusen, isn't relevant to this case. This is all about her and her effort, her agreement. Their revenue from other reps isn't relevant. Our revenue from other reps isn't relevant. It's just about what Van Dusen does. Everything else is overbroad from a standpoint of discovery. It can't possibly be relevant. It's just Van Dusen that they're alleging has done anything here. We're allowed to compete with the use of other reps. I mean, and so our position is we did respond to the order in full. To the extent I have anything that we can supplement with, I'm happy to do that. But I don't know what that is right now because frankly, I've been doing this almost 20 years and I've had very few instances where anybody I've represented was as thorough in her responses as Brandy Van Dusen was. I mean, seriously, here's Richard nodding. And it was crazy. Like the most organized person on the planet and produced over 3,000 pages of documents. She's got it down to like the day, what she's done since she came to work for us. Where she went, what she did, I mean, who she talked to. They have everything they need to know about what she's doing for Caroline Palliative since she left, everything. At some point, the plaintiff's gonna have to come up with their own stuff to prove this case. I don't know what the more we can give them.
All right, thank you. Mr. Bohannon, last word?
Yes. Well, first, Your Honor, I was hearing a lot of words like overbroad and irrelevant. That might be pertinent if this were a discovery request. It's not. It's a court order. We already once argued about whether or not this was relevant, the relevancy, and we agreed to a stipulated court order, and they're in violation. Second, while they did produce some documents, and I didn't go through all 8 of the categories in detail, every single category is deficient. It's not complete. We have evidence in the record that there's tons of documents that they didn't produce. Third, when it comes to this whole argument about the revenue in category G, of the order, once again, it's illogical what he's saying. He wants us to show their damages or how we were damaged. How we were damaged is based on the revenues she has been providing for this Caroline enterprise. And this Caroline company holds itself out as one company. Their website, it's one website for Caroline Health Group, and it has two companies in it like this. Our company set up similar. They operate under one HIPAA license, one HIPAA agreement. She's taking people from the hospice organization to meetings with these referral sources to help sell hospice. And that's what's in the record. So we just ask that the court enforce its order and require them to produce the documents that they said that they would.
Your Honor, if I could
All right,
just
thank you.
respond.
No, that's it. I hear from the moving party, the non-moving party, and then I give rebuttal. I'm going to start right with, and I'm going to use the lettering that has been used in the order because that is most convenient for discussing these various different categories. I'm going to start right with the heart of it, which is G. And I don't have to determine whether hospice revenue is relevant or not, because as plaintiff's counsel has aptly noted, this is not a motion to compel the discovery originally. That was already set, and it resulted in an order that is an order of the court, but it was arrived at not through argument and a hearing, but stipulated to. So all I'm enforcing is the court's order that was entered pursuant to what plaintiff and defendants determined was appropriate and stipulated to. And in G, it says, subject to a protective order from June 1, 2019 to the present, Caroline Health Group, LLC's palliative and or hospice admission and revenue data from each source that Van Dusen contacted and or solicited. And it seems to me what I've heard is a big dance around this whole thing. There is no, hospice isn't relevant. Never mind that palliative and hospice are, one turns into the other. Never mind that it was stipulated to. I didn't make this language up. This is what the plaintiff and defendant stipulated to, that it would be palliative and hospice admission and revenue data. And then at one point in the briefing, I think the defendants say that, well, she didn't solicit anybody. Well, it asks for the admission and revenue data from each source that she contacted and or solicited. And then I've had the argument that the underlying agreement is too broad and not enforceable, that all of this is irrelevant, that, this is just a big dance around what the real thing is here. And that is, this was stipulated to, and it now is not being provided, and not even denied that it's not being provided, but the argument that it's irrelevant. So I would order that the items requested in G be provided. H, again, we're dancing around the issue here because the complaint that the plaintiff had about H was that what was provided was not legible. And actually, in their response, the defendant said, oh, we produced it, attached as a sample of what we produced. Well, I looked at it. It's their Exhibit F, I think. It's not legible. So, the plaintiff's point is well taken. Then going to B, I'm looking again at what was ordered pursuant to the stipulation, the letter that went between the two sides addressing what the deficiencies were, and then the relief that's requested today, and then any response that the defendant had to the relief that's requested today. I don't see that the defendants have responded to B at all. And the only deficiency that I see is that the plaintiffs just wanted the defendants to confirm that they're not withholding any documents concerning solicitation of Van Dusen to work for any Caroline entity. So that has to be provided. With regard to C, again, the letter says, just confirm that the defendants have no emails, texts, social media messages, or other communications responsive to this subpart. Well, the response for today's hearing from the defendant is Ms. Van Dusen has produced extensive and responsive records showing each entity she has contacted on behalf of defendant Caroline Palliative Care. Okay, well, please answer what was ordered in C, because that statement may be true, but it does not tell me or plaintiff that C has been answered. With respect to D, the complaint was that please confirm defendants aren't withholding any documents responsive to this subpart. And, you know, with several of these, there has been some response. So the request is, well, confirm you're not withholding anything. The answer for today's hearing is Ms. Van Dusen has produced extensive records showing her work on behalf of defendant Caroline Palliative Care. Okay, well, answer D. With regard to E, again, the complaint is confirmed defendants aren't withholding any documents responsive to this subpart. And that's the clearest answer we get. Ms. Van Dusen has produced all responsive records. So assuming, I'm going to assume that is true. I would like it to be stated in a more formal way as a response to that paragraph rather than just stated here today. But with regard to M, the request was for certain phone records, and the letter details exactly what the issues are with respect to phone records. It appears that some were produced, but the plaintiff wants to know, is this a full response? Because first of all, we don't know if what you produced was with respect to her mobile device, her desk phone, her personal phone, or all three. And the documents produced are dated June 2020 through October 2020. What about documents from July 2019 to June 2020? And the response for today's hearing with regard to those records is Ms. Van Dusen does not have any personal phone or mobile device that she used for work, and per the language in the order, no such information was provided. That's just a completely non-responsive response to the issues raised by the plaintiffs and to the request in M. So I would order that that be responded to. Q, it does say the request is what was produced is incomplete, and I think that was specifically described by the plaintiff how it was incomplete. And the only response we get from the defendant is all responsive documents were produced. So I would order that as well. There are other things that the defendant responds to, but they're not in the 8 categories that the plaintiff is asking for the relief for. And that would be B, C, D, E, G, H, M, and Q. I am granting the plaintiff's motion to enforce this court's order, and the defendant is ordered to answer those categories within 7 days after entry of an order from today's hearing. And I am also ordering the defendants to pay the plaintiff's fees and expenses incurred in having to bring this motion. Again, because this is not an initial discovery motion. This is a stipulated order that the defendants apparently have stipulated to and then turned around and completely turned it on its head and argued that it's irrelevant. And I think that is meriting sanctions that will be paid to plaintiff for having to bring this motion. And
okay.
Mr. Bohannon, you'll have to have the appropriate orders entered.
Okay, thank you, Your Honor. I will do that. Thank you.
All right, thank you. that'll conclude this hearing.
Thank you.